Good afternoon, everybody. My name is Tamina Ahmed. I go by the nickname Tia. I've worked with most of you. I've been with the firm for about 23 years, and it is my pleasure to help present this team of experts. Bill Bartels, who is known for his cargo shorts, and Zane Uribari, who drinks opposing counsel's tears. Let's see the cup. There you go. I'm in the Woodland Hills office, but as you know, we're all virtual. All of our attorneys in all 13 offices are virtual, and we look forward to the pleasure of working with you and seeing and meeting all of you one day soon. With that, I'm going to hand it off to Janine.
Hi, everybody. Janine Lewis from Bradford Barthel. I'm the Director of Marketing, Quality Assurance, ADR, and Sports Marketing. So if you have any questions, please give me a call, and we can answer those questions on ADR. Love ADR. If you have any files with that, you can refer those to our office. We have many very talented attorneys in that venue. Thanks.
Okay, Karen.
Hi, everyone. My name is Karen Mejia, and I am from the Woodland Hills office. I rejoined BNB back in December 2020. So my home boards are mainly Van Nuys, but I've pretty much covered all the boards from up north all the way down to San Diego. So, I mean, I look forward to working with everyone.
Thank you. Brent?
Yeah, good afternoon. My name is Brent Smith, and I work in the San Diego office. So I obviously handle that venue, but in the past I've handled venues in Orange County and Los Angeles as well. And I've been practicing workers' compensation defense since 2003. So I'll hand it off to Suki.
Thank you. Good afternoon, everyone. My name is Suki, and I'm an attorney out of the LA office. I've been practicing for about 17 years, and the LA office covers the LA boards and the Van Nuys boards, and also virtually all other boards. So feel free, if you have any questions, to direct them to our office.
Thank you, Suki. Okay, Don.
Well, thank you. Happy Thursday, everybody. We're almost there. Happy weekend. Enjoy it, please. I want to thank you for taking the time out of your busy day to join us and Bill and Zane on this fascinating topic, med legal fee schedule, something that's going to be that's on the foremost of most of our minds and very problematic. I know that you're going to enjoy this presentation. Bill and Zane are excellent presenters. Both of them have been doing workers' comp for just shy of 20 years, and both of them are partners at B&B, and I think after listening to them, you'll know why. I do challenge you to submit a question that they can't answer. I always like seeing that. I suspect you're not going to be able to, but we'll find out. I am known for really bad jokes and riddles. We don't have a lot of time today, so I'm just going to go with a real quick bad one. Why did the little boy cross the road? That's right, to get to the other slide. I apologize for that. Anyway, just a few things about the firm that I want you to know about, that some added value that I want you to take advantage of. First, most of you know about our rating department that does an analysis determine whether the AMA guides have been properly applied. We find that 80% of the time they overstate the amount of impairment in PD. Thus, we've been able to identify tens of millions of dollars in savings for our clients over the years. Well, as a result of that, we have a little black book of the good, the bad, and the ugly on doctors' PTPs, QMEs, and AMEs up and down the state of California. Pretty much have every doctor in that book. So if you're facing a panel with 1, 2, or 3 doctors that you don't recognize, or somebody's proposing an AME that you don't need to know more about, or you need the background on a PTP, give me a call or email me, and I'll be happy to, 1, go to our rating department and get that information, and 2, since we're a statewide firm, I can go to the managing attorney of that local office, and he or she can talk to their attorneys and get some insights for you. Number 2, for today's webinar, you are getting a continuation credit. If you require any more credits or want to get up to speed on any other topics, please go on our website. We have over 50 recorded CE accredited webinars. Just take a look at those, review them, let Tammy know, and she'll get you your certificate right away. Finally, our blog, the newsletter that we issue weekly, if not more than that, We've got articles, updates, labor codes, regulations, news and review, lots of things that you need to keep up to date in our ever-changing workers' compensation system. So please do take advantage of that. So without further ado, we'll ask Bill Bartel to continue. By the way, if he yawns, please give him a break here. Despite his advanced age, he just became a daddy again. Bill and I are about the same age. I just had another grandchild. He had a baby. That tells you about our relative sanity. Good luck, Bill.
It's untrue. We are not the same age. Before the King of Cargo Shorts talks, I'd like Zane's got to say something. He's just too damn smart to not have say anything. And Zane, again, please talk about the books behind you.
Yes, my lovely books. As long as we don't hit them, they won't flap in the wind here. I'm Zane Uriberry from the Ontario office. I will be assisting with questions, getting those answered, but please submit them. I know some of you have already done that, and this is great. And Bill and I will go over some of the questions at the end of the presentation, but without further ado, here we go with Bill.
Thank you, Zane and Don and everybody else. Really appreciate it. Yeah, I am Bill Bartels, the aforementioned King of Cargo Shorts. Usually it's just my white legs that are blinding people, but I looked at myself and I'm kind of white right now because of the lights, but I don't know what that's all about, but hopefully you guys can tolerate it. I am a partner at the Anaheim office where I am sitting for the first time, well, actually second time in about a year. I just came back and I thought I'd wear a jacket in the office because that's what everybody does. So I'm going to talk to you guys about the changes in the regulations from 9793, 9794, and 9795. There's a lot of material to cover. So if you will, please indulge me, ask questions online. And at the end, like Zane mentioned, we'll talk about some of the best questions. So if you try and win the best question submission. I'd normally like to take questions as we go, but there's just so much material that I'd like to get through it. And chances are you're going to ask a question that may be covered in one of my 70 slides. Yes, it's long. Look at it. I think it's pretty accurate. It's actually very accurate. I worked really hard on it. So if you guys need further information or further reference, feel free to use it. So again, we'll hopefully talk a little bit at the end about some of the questions you may have. And heck, if we have time, maybe I'll give you a bachelor update. Who knows? You know, let's talk about old Matt. You know, he's been a rock. Anyways, moving on to the real stuff. So as you guys should be aware, if you're not, it's definitely time to get aware. There's been some substantial changes made to the regulations I previously mentioned. These are going to have a pretty significant impact on how claims are adjusted, certainly on how doctors are paid, and probably some litigation with any changes to statutes. We always see litigation. It's kind of why we have jobs. So I imagine there's going to need to be some clarification of some vague and ambiguous terms, which we'll get into. So without further ado, that's the first time or the third time somebody said that. So there's been a lot of ado, evidently. Let's jump into this. So when was the last time this was changed? It was back in 2006. So there were certainly some changes necessitated, and maybe you guys have encountered some litigation with respect to 4622 issues and the challenges to the prior billing schedule that seemed to be problematic. Along with the changes in the regulations, the DWC issued background information, a statement regarding the background. And I'm going to go over that, and we'll kind of ease our way into the actual changes. But I just want to give you a little bit of context first, where all these things are coming from. So according to the DWC, and they are very fine people who work very hard over there, the goal is always to improve the delivery of the medical legal evaluations equitably for both workers and employers. It doesn't always happen, but that's the goal. So empirical studies, as it says here, have been conducted recently, which demonstrates that the prior fee schedule, the ML 104s and 103s and such, was being abused, and so we needed some new changes. So specifically, the DWC issued a statement of reasons that said the increase in hourly billing is not matched by an increase in complexity of matters reviewed by physicians. So in other words, that old ML 104 category, the complicated, and this carpal tunnel injury so darn complicated, we got to bill, our hourly rate for it. That was being abused. It was being used on every single bill there was, whether it was a simplistic injury or complicated, and that was not the intention. So honestly, the doctors, and I understand they're business guys and they want to make some money, they were billing at the ML 104 level, certainly more than they should have. And what the ML 104 allowed them to do was to bill an hourly rate. So the DWC said, hey, I got an idea. Let's not do an hourly rate for these things. Let's do a flat rate and then add some complicating factors. And so that's what we did. Again, the DWC mentioned that the fee schedule complexity factors, which used to be how we determined what was billed, were being abused. And that complexity factors were kind of vague. I actually did training on this, maybe with many of you out at your office back when we used to go places. And there were all kinds of disputes about how many hours. I had a psych report, still kind of fighting it actually, where there was 64 hours billed for a single report. So the charge was crazy. We're still fighting and we're actually going to be set for trial again. And I think there was enough of that such that the DWC said, okay, we got to make some changes. And this, again, this just goes to what I'm saying earlier. It also demonstrates, the DWC did, that the aggregate spending for medical legal expenses has increased by 46% from 2007 to 2012. I think a lot of that, again, is that medical providers just started saying, hey, okay, well, it's bill ML 104, I can justify it. So here's my favorite statement, and I like this little emoji. This is what the DWC said, adding appropriate objective criteria to the existing medical legal fee schedule and eliminating complexity factors should alleviate the situation. And that's pretty damn funny. Again, I think it's a noble goal to try and reduce the situation and the complexity factors. But I think honestly what we're going to be doing here and what we're all going to be seeing over the course is probably in particular the next 6 months or so, is that one situation's been alleviated and another one's been initiated. So here's a lot of words, and I'm not going to read these to you. I wanted to put this in because this is what the specific purpose was included by the DWC. The important stuff for me is down about the middle of it. It says, again, the hourly billing system has been shown to be amenable to abuse. And so, again, the DWC, and bless them for doing this, they decided to make changes. And the good thing is that I know the DWC will continue to monitor the recent changes, so we're going to get more changes. But that's what we do. We evolve. This is how it all goes, and hopefully we'll get it to a place where it's again equitable for everybody. I have some concerns about it, and I'll tell you about those in a little bit. I'm sure you do too if you've heard anything about these. This is talking about a hearing that the public was invited to for comment. I think mostly doctors attended that. They certainly gave their comment, and they're going to do okay by virtue of these new regulations. So I like this too. So this is where they're trying to come up with a solution to a problem, and this is a direct statement from the DWC in which they said the implementation of a predominantly fixed fee for all procedure billing codes, which is what it has been changed to, is anticipated to reduce frictional costs. So I like the word frictional, or the words frictional costs, because essentially that, as I put here, is a euphemism for attorneys are greedy and doctors are greedy. And again, I know I have a friend who practices both defense and applicants work. I won't mention his name, but let's just say he shares the first name with me and his last name rhymes with happen. He made a good little living out of presenting med legal disputes at all the boards. And I like Bill, he's a good guy. And he just was exploiting the procedures that were available to him. So there still will be disputes regarding 4622, but these regulations are meant to minimize them. So again, so they're trying to come up with a solution to a problem, but is it a problem to a solution? Wow, what a crafty play on words. Anyways, the WCIRB reviewed the analytics and they offered some projections of an 11% increase in record review costs. I don't know if you guys have heard of it. Hopefully you have, but there's a new charge for $3 per page for record review. By my guess at this point, because again, this is still new, I would imagine that 11% is a pretty conservative amount, and we're probably going to have a lot higher increase in overall record review. Some projections have costs going from about $384 million to $469 million under the new fee schedule. So the doctors are going to probably do okay on this. These estimates contemplate 55% increase in payments for missed appointments, something new added to the regulations that we're going to talk about, and a 20% increase for charges that were formerly listed under 102, 103, and 104. Those were your run-of-the-mill initial evaluation, supplemental. Those have all been modified now, and all those ML 104, 103 numbers no longer apply. So we're going to hopefully reduce frictional costs, but we're going to absolutely increase actual costs. And I like this statement by Dave Belushi. I got this on the statement from the WCIRB, so that the providers think that it's not enough, providers meaning doctors, think that it's not enough, and on the carrier side, they think it's maybe too much, so we'll see. We'll clearly monitor it. And as I mentioned before, they're definitely going to have a lot to monitor because there's some massive changes and some ambiguities which are certainly going to be exploited by various individuals. So here, let's get to it. So here's where it starts. This is beginning on April Fool's Day, which is an important day in my life for various reasons that I'll leave out. But as of April 1, 2021, this new schedule kicks in. So basically, in a nutshell, any medical legal evaluation where the examination occurs after April 1 will be subject to the fee schedule. Any medical legal testimony after April 1, subject to the new fee schedule. And any supplemental reports, those are not in-person evaluations, those are just reports that are generated after reviewing documents. If they're requested after April 1, then the new fee schedule will apply. If requested before April 1, 2021, the old ML, what would that be, 102 or 103 should be, will apply. But essentially, we're into it now. This is what we got, and this is where we're going. So from this point on, you should just assume that everything is going to be the new schedule. So on the next two slides, I put this in for a quick reference for y'all. So y'all, I'm not from Texas. Anyways, but I put this in so you guys could refer to this very quickly because again, there's a lot of nuance to the changes made and to the new amounts. But this is something you can look at real fast if you just need to say, oh yeah, how much is that new flat rate? As you can see here, I've listed these guys. So the missed appointment charge is $503.75. We'll get into details on that. The comprehensive medical legal evaluation is $2,015. Follow-up medical legal evaluation, $1,316.25. And the supplemental medical legal evaluations is for $650. That's for not an in-person evaluation. Again, I'm going to break all this down later. Medical legal testimony has been increased to $455 an hour from $250 an hour. Review of Sabrosa recordings are $325 an hour. So we still have some hourly charges, just not with the frequency that we did before. And here's the big guy. It doesn't seem much. It seems so small. But when you add $3 per page on some of the cases we all have, that presents a pretty daunting increase in charges. There's also modifiers that will increase the base rate only. We'll talk about these all a little bit later, but the interpreter, AME, is the report a psych. For example, if you look here, it says increased by 100%. What that means is that if you have a psychiatrist, the initial evaluation, which now is $2,015, is doubled right off the bat. And that is irrespective of records. That's just the flat rate. And again, we're going to get into these in greater detail a little bit later. There's a lot to do here. So let's jump into the missed appointments. So the missed appointments is something new that the DWC did. I think, understandably, I don't know if you guys are familiar with this, but applicants aren't always reliable. And sometimes when you make a QME evaluation for them and you're thinking, goody, the case is going to move forward, they don't show up for one reason or another. Just happened to me the other day. My applicant called and said he's tired of evaluations and doesn't want to go anymore. So, hey, can't blame him, but that's not how it works. The unfortunate part is that the doctors were having all these schedule changes. They needed some relief, and this is a way to appease some of the doctors. And again, I think it's reasonable. So the new charge now is for $503.75. And if you look here at the lengthy statute that I've decided to include, basically the doctor is going to be able to bill the $503.75 charge for any time there's a missed evaluation. Let's see here, where the injured worker doesn't show up for the evaluation, where the interpreter doesn't show up for the evaluation, or where it's impossible to go forward with the examination, or in the case of the appointment's been canceled within 6 business days. So within 6 business days, the doctor, if it's canceled, the doctor can send a bill for $503.75, and you have to pay it. This is, again, one thing that the DWC is doing to try and help out some of the doctors. But there's some good news for the defense side. And the good news is that we now have a statutory basis to potentially take credit from an applicant's award. So before, I know we'd be upset and we think, gosh, dang it, that guy didn't show up again, that son of a whatever. And, you know, we'd go tell the judge, hey, judge, he didn't show up and he's a jerk. And the judge would say, sorry, I'm not going to do anything about it. I'm not going to reduce his money. Well, now there is actually a statutory basis. So this is actually the language from the statute. And it says, if fees for failed appointments and for late cancellations are incurred through the fault or neglect of the injured worker or his or her representative, the employer may seek to credit those charges against the injured worker's award. So as my friend and colleague in the office, a couple doors down now, Rob Tomlin, pointed out to me, it's permissive language, but it's not mandatory. So it's not a shall get a credit, it's a may get a credit, which means you have to work for it a little bit. Again, there's a statutory basis for it now, so I think that when that happens, you submit a formal petition for credit with a proposed order, and you make it a little bit easier for the judge to potentially issue that credit. Again, the judge is going to want to hear from the other side. There's no excuse for good faith reason for missing an appointment, but I think before any judge is going to actually sign off on a credit and allow $503 to be deducted from an applicant's CNR, he's going to want to hear from the other side. But again, it still may be difficult, but at least we have a legal basis to do it now. We can actually plant our foot in the law and say, Judge, this is what the statute says. So it's good. So that's a good thing and a bad thing. So I guess that's how it is. By the way, I practiced family law for several years, and that's how it always is in family law. Some really good, some terrible. Nobody walks out of family law going, I won everything. So again, if a law is kind of split down the middle and makes some people happy and some people angry, it's probably doing what it's supposed to do. Okay, so let's get to the in-person evaluations. There's 2 kinds. This is the comprehensive medical legal examinations under 201 now. The flat rate, as previously discussed, is $2,015. And this includes all comprehensive medical legal evaluations that don't qualify as supplemental or follow-up medical legal evaluation. So it's a little bit of a catch-all. It can only be conducted once every 18 months. So as the attorney for the DWC recently said on an online webinar, as of the date of the examination, the clock starts ticking, and 18 months and 1 day from that first comprehensive medical legal evaluation, you can have another comprehensive medical legal evaluation billed at $2,015. Until then, it's going to be a follow-up, which we're going to talk about in a second. The statutory definition of this is codified in Regulation 9793C. Basically, it says it's an evaluation which includes an examination of the employee, meaning in person, and results in the preparation of a narrative report and is performed by QME, an AME, or as we know, sometimes a PTP gets involved and wants to declare themselves a med legal evaluator. Always contest that. That's another slideshow. We'll do that some other time. But at any rate, this is basically your initial medical legal evaluation. This is the one for which the providers were previously billing at ML 104 and saying it was super comprehensive and super complicated. Now it's just flat rate, $2,015, subject to the modifiers and the page review that we're going to talk about in a second. So here's that page review. So the first 200 pages of any document review are included in the flat rate of $2,015. So from page 201 on, you're going to be billed at $3 per page. Now, that's very onerous, and that could be a problem because, again, we all have some very old cases, maybe prior surgeries, and if there's, 2,000 pages, which is not unheard of, we have boxes out in the hallway out there that have that many documents in them, they're going to be charged at $3 per page. So if you have 2,200 pages to review, that's, potentially $6,000 extra dollars added on top of the $2,015 flat rate. So yes, it's kind of scary, and yes, it's going to take some work by your defense attorney and or you if it's a non-litigated case or a pro per case, to make sure that the pages being provided to the doctor are appropriate. We're going to talk about those in greater detail because it's a big issue, obviously, and I'm sure you're thinking, what about proof of service? What about subpoenaed records? All good questions. We're gonna talk about that in a little bit. Okay, so back to the comprehensive medical legal examination for now. So again, the categories utilized for an in-person evaluation. Subsequent in-person evaluation, which takes place more than 18 months after the most recent comprehensive medical evaluation. So I kind of already said that, sorry. So here's the second kind now. The second type we have of the types of reports that are going to be issued by QMEs, AMEs, etc., are the follow-up medical legal evaluation. So as you'll notice, the flat rate for this is $1,316.25. I don't know why they included the extra quarter. You can just round up, for crying out loud, make math easier, whatever. But this is a little bit different. This is for an evaluation which is conducted in person. This is the second of the in-person evaluations, and it has to occur within 18 months of the initial comprehensive medical legal evaluation, as long as it was performed by the same physician. If it's a new physician on a new injury, potentially new comprehensive medical legal evaluation at the $2,015 rate. But if it's a follow-up by the same physician for the same injury, maybe our applicant had surgery and we want him or her to be reevaluated. This, as long as it's within 18 months, this is going to be the appropriate category. Here's the definition. I'm not going to go through it exactly because it's pretty identical to the comprehensive medical legal evaluation. The big key here, and I put it in italics, is an examination of the employee, meaning that the employee or the injured worker was actually evaluated in the office by the medical provider. So this is also subject to the increase for page review. As with the comprehensive medical legal evaluation, the first 200 pages are included in the base rate, but everything from page 201 on is subject to $3 per charge, or per page rather. Did I put per charge? That makes no sense. I'm gonna have to fix that. At any rate, this is where maybe we get some subpoenaed records, and the comprehensive medical legal evaluation is already done. We get subpoenaed records which show that our guy or gal is a crook or has otherwise had prior surgeries and other information that wasn't shared or was shared, and we want to provide these new documents to the doctor in addition to the in-person evaluation. We get the first 200 free, and after that, it's a $3 per page charge. Okay, so the third and final type of reporting that's going to be issued by medical legal evaluators at this point is the supplemental medical legal evaluation. This is not for an in-person evaluation. This is when you send the hospital records or some new documentation to the doctor and say, hey, doctor, let me know what these records, how they're impacting the case. Also will be billed for Sabrosa film. I just recently sent a Sabrosa film to a doctor, got it back. And in his report, which was highly favorable, thank you, he's going to be able to bill for $650 for the supplemental report, in addition to the hourly charge for reviewing the Sabrosa, which we'll talk about in a second. So there's something that's key here that I've again put in italics. The fee for this service includes a writing of a report after a request from a party for a supplemental report that for receiving or reviewing records that were not available at the time of the initial or follow-up comprehensive medical legal evaluation. So that's important because if the records were available and maybe the doctor already commented on them, then that doctor may be precluded from billing for an additional review. We're going to talk about that in a second. Again, the statutory definition, just because it's important to have, this is what we rely on, is the definitions of stuff. It does not involve the examination of a patient. It simply is a review of records, test results, or other medically relevant information that could be subpoenaed records. And it's performed by the qualified medical evaluator, the AME or PTP under some circumstances, and results in the issuance of a report. So with this now, the $3 per page charge is going to be slightly different. Now you only get 50 free. So you get $650 flat rate, and now the doctor is able to charge $3 for every page from page 51 on. So presumably by the time the supplemental medical legal evaluation is done, there's already been at least one comprehensive medical legal evaluation, and the doctor's already been provided with substantial amounts of documents, hopefully. This should really be utilized after you send everything to the doctor with the first request when new information becomes available. Again, maybe we get new subpoenaed records, maybe we get new Sabrosa. And then we want the doctor to comment on it, but we only get 50 free pages or 50 pages included within the $650 flat rate. Okay, so fees are not allowed for this. The statute goes into detail about what is not allowed. And so under the following circumstances, a fee cannot be requested. Well, it can be requested, but it could be rejected if the doctor makes a fee request for the following. So under the following circumstances, number one, following the physician's review of information which was available, I should have italicized, which was available in the physician's office for review or was included in the medical record provided to the physician prior to preparing a comprehensive medical or follow-up report. So, in other words, we send documents. Say we send 500 pages worth of documents, 200 pages of those involve Dr. X, and we want our QME to review them. The QME has those doctors provided to them, signs off on it, as we'll talk about in the coming up sections about declaration. Those records are now available to the doctor at the time they're provided, presumably, hopefully, at the time of the initial evaluation. If those records were provided and available to the doctor, then the doctor should review them immediately. If the doctor fails to, and those records were available, but the doctor didn't conduct a review, then the doctor must issue a report, as we'll find out in a second, but he or she also can't bill for it because those records were available to him or her. The other instance where fees are not allowed is when the physician is addressing an issue that was requested by a party to the action to be addressed in a prior comprehensive evaluation. So with the first comprehensive, for example, with the first comprehensive medical legal evaluation, we say, doctor, here are the applicant's reports from his prior surgery in the year 2000. Please comment on the impact those records may have on the applicant's current condition. And the doctor doesn't do it. The doctor decides, I'm just going to ignore that. Maybe I'll issue a supplemental report and get them for a few more. Well, you can't do it anymore. It used to be a thing, right? I mean, that used to be what QMEs would make a living off of. Oh, I didn't address those records. Darn it! I guess I'll have to issue a supplemental report and talk about it, and then bill for it. Well, they can't do it anymore as long as the issue was specifically addressed by the parties. So what does this mean for us? And what does it mean for you guys? So for us as attorneys, we got to make sure that we're preparing very detailed advocacy letters and providing very clear information to the doctor, very clear reporting, very clear lists of the documents that we want the doctor to review. What does it mean for adjusters? Same thing. In cases where you are not represented, then you definitely need to make sure that the information you send to the doctor is clearly addresses the information you want him or her to address, and clearly identifies the documents that you're sending. So, okay, a couple of examples. These are always great. Hypotheticals, love them. So, example, prior to the initial comprehensive medical legal evaluation, the parties provide subpoenaed records from prior surgery. The QME attests, again, we're going to talk about the declaration and attestation momentarily, but the QME attests that the records were reviewed, but does not explicitly provide comment on the records within his or her issued medical report. The parties later require clarification and send a request for the doctor to discuss the impact of the prior surgery. Again, this is now the second time the parties have requested this. So the doctor issues a report doing what the parties asked the second time. Will the doctor be paid? Everybody? I can't hear you. Answer no. So because the records were provided to him previously, him or her, dang it, and were therefore made available in the physician's office. So the doctor is obligated to issue a report, but cannot get paid for that. So now another hypothetical. What if the doctor reviews the prior surgery records and provides a summary within the initial report? So unfortunately, the parties have a specific question regarding the surgery and the impact on the case, which is not expressly answered by the doctor in his or her first review of the documents. So, like, for example, will the effect of the prior laminectomy on the lower back preclude additional surgery? A very specific question. So will the doctor be paid for that report? As usual, as good attorneys, we all say, well, it depends. So did the parties specifically request the doctor address this issue about the prior surgery and the impact on subsequent surgery? If so, then the doctor is obligated to issue the supplemental report and cannot bill for it, assuming he did not adequately answer the question. So, but if the records were not just merely summarized and no specific question was posed in the original advocacy letter, well then, yeah, then there's no issue to be addressed by the doctor. So the doctor can issue a report, a supplemental medical legal evaluation, and bill for it, because again, the doctor is now addressing an issue that was not expressly requested previously. So again, and I said this earlier, it's really important, because in order to avoid issues where we need clarifying reports or confusing QME findings, it's going to be really important to make sure the advocacy letters and the list of documents, more than anything, is clearly provided to the doctor. We might run into some problems with the Maxim case, which, as you guys may know, determines what kind of information can be provided to med legal evaluators. But again, it's pretty important to make sure we're clearly identifying issues and facts for the doctors so that they can properly address them in supplemental reports and bill for them, and we don't run into the issue where we are requesting a report and at the same time saying, hey, we're requesting a report, doc, and you're not going to get paid for it, because nothing's going to twist a doctor to the other side's position more than telling them they have to do work and not get paid for it. Okay, so here's what holds the doctors accountable. Failure to issue a supplemental report upon request because of the aforementioned inability to bill for the report constitutes grounds by for discipline by the administrative director. This comes straight from the statute. I think this is probably not something that the doctors lobbied for, but it's what they're stuck with. And so, again, I think as long as everybody is being clear with the issues and facts being provided, clear with what is being provided back to us, then we shouldn't have too much problems, but you all know we're going to have problems. It's just how we do it in workers' compensation, California. Woo! Okay, moving on. Sorry, I'm talking a lot of coffee. Medical legal testimony. Used to be that you were obligated to pay $250 an hour, 1 hour prep, 1 hour deposition time. We should have been sending checks for $500 to doctors prior to their cross-examination. That's now been increased. Funny here, the statute says that the physician shall be reimbursed at the rate of RV7, which is $4.55 an hour, or his or her usual and customary fee, whichever is less. So I'm guessing $4.55 is going to be across the board. I don't think any doctors are going to bill less than they can. I don't blame them. I mean, if this is what you're allowed to bill, then they should bill it. So what do you guys do with this? This means when we have cross-examinations coming up, we need to pay the doctor in advance, and now we need to make sure they're getting $910. That's $4.50 an hour for 2 hours, 1 hour prep, 1 hour depot. And again, the doctor, as with before, they can bill for additional time where warranted. So here's where it gets a little bit interesting. If the medical legal testimony, if the deposition is canceled fewer than 8 calendar days before the scheduled deposition date, the physician shall be paid a minimum of 1 hour, $450 for the scheduled deposition. So I know this is kind of squirmy and maybe a little bit slimy, but as attorneys, what we do is we interpret statutes. And I see there the word canceled. Canceled to me is a different term of art from postponed. So maybe before we outright cancel a cross-examination, we elect to postpone it, and maybe we can get around the fee. Not sure how that's going to work. I'm sure that's going to be developed over time. There's going to be some, not Supreme Court case. I mean, we're not that important, but there'll be some case about it that clearly defines what canceled means. Whatever the case, you know, to the best extent possible, attend the cross-examination. We won't have problems. What's interesting here too is the DWC and the new regulation provided for a way for the defense to get credit from a missed appointment, but there is no similar defense credit provision for missing out on medical legal testimony. So, for example, say applicant's attorneys, you know, on 4 days before a depo says, I'm going to Cabo. I don't want to do your darn depo testimony. There's nothing for us to try and get credit from the Injured Workers Award for this. Kind of makes sense. An injured worker isn't involved in medical legal testimony, maybe not their responsibility. Okay, review a Sabrosa recording. So this is, like I mentioned earlier, one of the areas where we still do hourly rates. And what is the hourly rate? It's $325 per hour, or the physician's regular rate, whichever is less. Again, I'm guessing we're going to get $325 per hour. The Sabrosa recording, when the doctor reviews it, must include a declaration which verifies the time that he or she spent reviewing the Sabrosa film. Just got a report back the other day. Doctor spent about 8 hours. Seems a little heavy to me, but the doctor will get paid 8 hours times $325 per hour. If I was any kind of good at math, I'd tell you what that is, but I'm not. So we're moving on. You guys, that's why we have these things, calculators. Woo! Okay, record review. Again, this to me is kind of the biggest issue that has come out of the changes to the regulations. As I mentioned before, with the 2 kinds of reporting, the comprehensive and the follow-up medical evaluations, 200 pages are included, and with the supplemental, 50 pages are included. So this presents the biggest change, and this is where the DWC was trying to get away from the hourly. They thought it'd be favorable to the doctors to do something a little bit more objective, which is a per-page review. So it's very important to understand what the statute says in this. And here it is, the review by a physician of documents sent to the physician in connection with a medical legal evaluation or a request for a report. The documents may consist of medical records, legal transcripts, test results, and other relevant documents. Other relevant documents meaning maybe subpoenaed records. And for the purpose of record review, a page is defined by 8.5 by 11 single-sided document chart or paper. You can't get around it by submitting a PDF. The PDF has a page count. The page count's what's going to matter. I listened to, like I said, I tuned in for a DWC website review of this, and one of the big questions was, well, what documents does that mean? Does that mean proof of service? Does that mean blank pages? What does that mean? And Dr. Feinberg, for whom I have a tremendous amount of respect, he was one of the panelists, and he rightfully said, if I get a document, I'm reviewing it. And honestly, that makes sense to me. How do you know what's relevant or not relevant unless the doctor is reviewing it? So I think it's our responsibility as the defense to maybe cull some of the documents we may have, such that we're only providing relevant documentation. Now, this may end up by in a demand or an objection by applicant's attorney saying that we didn't provide everything. Again, we may have to attend a hearing, show the documents to the judge to say, hey, look, we provided everything we can. The only thing we culled were the duplicative paperwork, the proofs of service, maybe the face of the subpoena, something that's not necessarily going to go towards the medical disability or the medical findings. Yeah, okay, so as far as this, again, this references back to what I said earlier about documents provided to the doctor and the obligation to basically conduct a review of them right when they get the documents. So here's some potential problems. I'm sure in all of your heads right now, as the first time I heard this, I was thinking problem here, problem there, this is going to be an issue. I'm sure all of you guys are thinking the same thing. What if applicant's attorney sends over 10,000 pages of, blank or, stories from their kid, and the doctor has to review them? That's a possibility. There's some guideposts or some safeguards that are put in place, but this is potentially the part of the new regulations where I think it's going to drive the cost of the reporting. So, for example, Kaiser records. We all deal with Kaiser. Kaiser, at the end of every report they have, every daily report, has one page that only says end of encounter, and so that's going to be considered a page. Again, according to Dr. Feinberg, it will be. The doctor has to review it. So again, we need to cull the records. My good friend and colleague, David Hubner over here, has made a little, he's kind of perfected it actually. He had recently had a file that had, gosh, I think it had something like 3,000 pages on it. And he spent, quite a bit of time going over it, and he eventually got it down to 550 relevant pages. I mean, that represents a substantial savings to you guys. So we're going to have to work together with the applicant's attorneys, with our opponents, to try and make sure that we're providing appropriate and not duplicative documentation. I'm a little concerned about this. Most of the attorneys with whom I work are good people. I can think of a few off the top of my head. They're good people. They just want to get the case resolved. And I know they're going to work with us and not try and artificially drive up costs. Then there's that 5–10% who are not. And I have names for them, but I won't share them here because we're a family show. But I'm a little worried about those guys. Those are the ones that I think are going to try and use this as leverage and say, hey, defense person, I've got 4,000 pages of subpoenaed records that I plan on sending to the QME. That's going to be $12,000 in additional charges. Why don't we settle, give the money to me? So that is definitely going to be a potential issue. It's going to be something we have to be careful of, especially with those firms with whom we don't maybe get along so well. And I just basically talked about that here. So here's one piece of information that I thought was very interesting. I was listening to the DWC seminar on this. I've referred to it a couple times. There's an attorney there, a real smart guy, who was talking about what needs to be done when the parties are going to send documents over. And what he said is that there's a meet and confer requirement under Labor Code section 4062.3. That's not correct. There is no meet and confer requirement. Meet and confer is a specific legal activity where you show up and have a discussion with your opposing counsel, and you determine whether you can resolve an issue, and if you can, how you resolve that issue. There's no such requirement within the statute within 4062.3. Instead, there is a statement if you have an AME that says the parties should agree on what documents should be sent to the evaluator, but there's no formal meet and confer requirement. Having said that, we really need to work with our opposing counsel. I think in most cases, and in my experience, I've already done this a handful of times with the new regulations. I've reached out to the opposing counsel and said, look, this is a list of the documents we want to provide to the evaluator. Unless you have something different or something additional, we will be providing these documents. In most cases, the attorneys review the list of documents I have provided and say, yeah, just go ahead and do it. That's all good. Again, I don't think applicants' attorneys want to spend too much time on this. There will be those that are gonna be problematic. And so what are we gonna do? What are we gonna do if we get a problematic attorney who's gonna say, screw you, I wanna send all these records. I don't care if you think they're relevant or not. I want the doctor to see them. At that point, I think for us, litigating it, we're gonna need to either do a petition to stay, which is sent to the judge right away, or maybe even file for an expedited hearing. I think if you're on an in pro per case, hopefully you won't have this same problem, because presumably an in pro per applicant won't be sophisticated enough to know this. But I think if you have an applicant's attorney and you're not represented, they may try and play games with this. Sadly, you may have to refer the file out. Okay, required declarations. We're doing okay on time. I told you I've got a lot to do, so we may not get to the bachelor report. I apologize. I know you all were looking forward to it. The new regulations require declarations from all parties, and this is to make sure that everybody's on the same page with the amount of documents that are being provided. So the first one the providers of documents are the first ones to send the declaration, but we're going to start with the doctors. So when billing under this code, the physician shall include in the report a verification under penalty of perjury, i.e. declaration, of the total number of pages of records reviewed by the physician as part of the medical legal evaluation and preparation of the report. If they don't provide this, they don't get paid. So as my English 101 professor would be very proud of me for this alliteration, no declaration, no remuneration. You just keep saying that over and over in your head. So again, they have to submit a declaration to you telling you how many pages they reviewed. And what you should do is compare that, of course, to the declaration that you provided and make sure that the numbers line up. That way they're not excessively billing. Okay, so here's our last big statute that I'm going to break out, and I got to get going pretty quickly on this because this is an important one, because this is the declaration that we have to provide. There's the full context of it, but I'm going to split it down. I broke it down a little bit. So any document sent to the physician for record review must be accompanied by a declaration under penalty of perjury by the provider that the provider of the documents has complied with provisions of Labor Code Section 4062.3. So again, I emphasize provider here because it doesn't say attorney, it doesn't say adjuster, it says provider of documents. So adjusters, you guys can do this declaration just as easily as we can, and our office will be doing it. The declaration must affirm that you've complied with the provisions of Labor Code 4062.3. This is where earlier I referenced the erroneous reference to a meet and confer, which is not required. But 4062.3 talks about providing the documents within 20 days of the evaluation, giving 10 days for the other side to object, also discusses QME, AME, ex parte communications. Again, the declaration just says that you have to comply with this, and it should be done as, again, italicized and emphasized here, before the documents are provided to the physician. The declaration must also contain the attestation as to the total page count. So again, this is where we say we're sending 1,000 pages, doctor. Your declaration, doctor, better also say 1,000 pages, and you better review those documents if you want to get paid. So any documents or records that are sent to the physician without the required declaration and attestation shall not be considered available to the physician. So remember earlier I was talking about the doctor being able to bill for documents available to him. If you don't provide the declaration and attestation and still 1,000 pages are sent, those records should not be reviewed by the QME because they are not available to him or her. Okay, modifiers, our last kind of big topic here, because these are gonna pump up, as this is a pretty cool thing right there with the percentage. I didn't see that till right now. These are gonna increase the flat rate of the reporting only. So the increases are set forth right there. For interpreter, 10%, AME, 35%. We already talked about doubling it for the psychologist. The internal toxicologist and oncology all increase the base rate, not the per page rate. It is clearly exempted by the statute that these only apply to the base rate from the comprehensive, follow-up, and supplemental medical legal evaluations. Interestingly, again, lawyer trying to critically read these statutes, the modifiers, this is what the statute says, 9795D, modifiers shall not be applicable to per page charges for record review in any of the procedure codes ML201 through ML203. Well, 201, 202, and 203 are comprehensive, follow-up, and supplemental medical legal evaluations. They purposefully omitted the one for medical legal testimony, so I'm not sure if that means that for medical legal testimony, if there's record review, an AME, a psychologist may be able to charge for it. I imagine somebody's going to try to, so we're going to have to keep that one on our minds and make sure that we're catching how the doctors are billing. Okay, so modifiers can be combined. So I gave an example here. So we have a comprehensive medical legal evaluation with an AME, and it requires an interpreter. Base rate, of course, is $2,015. We talked about that. You should know that. At that point, now we multiply it by 1.45. So 35% for the AME and 10% for the interpreter. So again, so this means that the base rates can go up pretty substantially. Maybe are there going to be more psych evaluations or psych allegations? I don't see how there could be because there's already a whole hell of a lot of them, but maybe this is going to initiate more psych complaints. I don't know. We'll certainly find out. Okay, and then the very last thing, we're almost done, is 12:58. The very last thing I want to talk to you guys about is EORs. So all medical legal expenses have to be paid within 60 days, of course. This is 9794. This is no different from what it used to be. There's still the timeframes for issuing an objection and for responding. Remember, after the second request, you have 14 days. Let's not forget that. That's still important. Hopefully, there won't be as many fee schedule disputes now, but those requirements still apply. The one thing I want to say to you guys about this, and then I'll finally shut up for a little bit, is it's important for you guys to be, and I'm talking to adjusters, to be clear on your explanations of reviews. I've gone to trial on many issues where EORs are used as evidence, and judges get furious when there's an EOR that is clearly a template that has, 6 different objections, maybe one of them's relevant. Under those circumstances, the judge is going to throw the whole thing out. So when you do your EOR, be particular. Say this is overbilled. This was not paid because it didn't meet the statutory timeline. We are contesting this bill because the doctor overcharged the per page charge. If I can say anything to you guys, please just remember that EORs are critical. They're critical evidence that are going to be submitted to a judge someday. So please make them clear. And I think that's all I got. So I went kind of long here. Sorry. Hey, Tammy.
Hey.
I can't do the bachelor report now. I'm sorry.
That's okay. That's all right. Next time.
Okay.
Thank you so much, Bill. I know that's a lot of information to provide in an hour, and we really appreciate. I think we are done. Thank you so much. Have a wonderful afternoon. Take care, everybody.